Good evening, everybody. Good evening. Hello, hello, hello. Welcome, welcome. We've got some things that have been filed today, so I'm excited to take everybody through these. Hello. Hi, Lily. Hello. Sick Click. That's a fun name. Ravioli. Hello. Yes, welcome. Welcome back, everyone. Jojo, Abby, good to see you all. It's been a little time, sorry, but I'm doing better now. So I'm definitely back up and going. Hello, Deborah. Welcome, welcome. Hello, hello, everyone. Hello. Yes, yes, Don. Well, welcome in, welcome in. So I decided I'd come on just a few minutes before my 7 o'clock central timing, just to make sure everybody gets their notifications that I am on. I'm up and running so far. Gaga, hello, hello. Hopefully not much more of that. Oh my gosh, I know, I know. Oh, I'm so glad. Yeah, I'm glad to be here, everyone. I'm glad to be here. It's been a little rough go of it recently, but you just keep moving on, keep going forward, and keep doing what you can do, right? Hello, hello. Oh yes, we've got tonight's orders laugh worthy for sure. Yes, I am doing better. I'm definitely feeling much better. I'm on the mend for sure. So I just need to make sure I take care of myself, and as we all should be doing right now. So, oh, North Carolina. Oh, hello, hello. Oh my gosh, I wish you the best. For all of those who have been affected by the hurricane that came barreling in. I feel like just because it's not in the media, everyone thinks that all of it's over, but needless to say, it's not. There's a lot of wreckage. So, yes, I am doing better. I am doing. Yes, I think so. I think so. Oh, from Wichita. Well, hello, hello. Welcome in. Welcome in. New Jersey. All right. Good to see you. Hello. Yeah, far from over. Exactly, Kristen. There's so much damage. So much. It's a lot. So, yes, cheery again, Randy. I do try to stay as cheery as possible. So if I'm not cheery, something real bad's going on. It takes a lot. It takes a lot. Oregon, Maryland. Oh my gosh, San Diego, Texas. Oh goodness gracious, Florida, all over the place. Well, welcome in, everybody. We've got a lot of stuff to catch up on. But again, I do need to kind of make my lives in smaller bites than I had been doing before, but we'll still get to all of it. Tonight, I will be taking you through two things that were filed in the DC case. So we have two filings. One is the government's response in opposition to defendant's supplement to his motion to dismiss on statutory grounds. That's a very long title. That just means this is their response to Mr. Trump's motion to dismiss. And then we have what I think is actually incredibly well written. We have an order from Judge Chutkan. It's a memorandum opinion and order. And this is 50 pages long. I mean, she's not playing around. She's like, I got stuff to say, and we're going to say it. And if you want to appeal it, that's on you. So it's pretty good. She really goes into a lot of the details, a lot of information to try to clarify her decision on allowing and not allowing certain things. So it's pretty good. Yes, no, not blocked, not blocked. No, I've been kind of out of it recently, but I am back. I'm back. Hello, Nikki. Good to see you. I'm doing well, Mara. Thanks for asking. I am doing well. Much better than I was. Hi, Mike. Good to see you. So, every once in a while, you just have to take care of yourself and you have to go away for a little time. So I'm glad to be back for sure, for sure. I've missed everybody. Yes, good to see you too. Good to see you too. So with that, we'll go ahead and jump into the DC case. I want you to remember, though, by the way, that tomorrow is the deadline for Mr. Trump to file his objections to the redactions in the for the appendix, for the immunity brief, right? So Jack Smith filed that immunity brief. We've kind of gone through parts of it, and the other part was an appendix. So he'd already filed that, and now he's filed this appendix, but Trump had wanted extra time to read through and make decisions on the redactions that Jack had already done. Judge Chutkan said, I'll give you a week, and that week is up tomorrow. So tomorrow, everybody, unless something weird happens, which is always possible, we should be seeing a huge appendix coming in. So that's going to give us some exhibits. It's going to give us more of that evidence that we've been looking for. So we'll be getting our hands on the evidence tomorrow. I'm very excited about it. Yay! Yay! I'm so glad. We're matching with the nails. Yes! Oh, great. We love it. We love it. So I thought this would be a great way to kind of get us back into the groove for the DC case, especially because we've got a 50-page order here from Judge Chutkan. And I will put in a side note. Many of you may not have heard, but we do have another filing out of Georgia, and I won't be able to go through it tonight, but I'm hoping maybe tomorrow I'll be able to, depending on when the evidence drops. But Fonnie Willis out of Georgia has filed a cross appeal on the issue of those 6 counts that Judge McAfee had pulled from the indictment. So we had 6 counts that he had felt were not proper given the facts and the circumstances, and so he struck them from the indictment. She's saying we're going to want those back. So she has filed a cross appeal, and I believe she filed this just yesterday. So I will be going through this too at some point to kind of give you an update on that. But there is a little bit of movement there in Georgia as we continue to wait for the Court of Appeals to come back in. Yes, I thought it was very interesting. Hi, Thomas. Good to see you. So, but what we have for tonight is the District of Columbia, and I'm just going to show you Jack's motion here because I really want to get into Judge Chutkan's order because she does such a great job. So, before all of this went all the way up to the U.S. Supreme Court, the D.C. case, there had been motions for discovery, motions to compel discovery, and motions to dismiss. All right, this was before it went up to the Supreme Court. Those all got paused and put on hold while it went up to the Supreme Court and then came back down. So when it came back down to Judge Chutkan, she said to Mr. Trump, dude, you got to get your stuff in order and let's go forward and revisit. So Mr. Trump has filed a few things, again, for his motion to dismiss on statutory grounds and has also filed based off of discovery questions. So this is just one of the government's responses to one of those motions to dismiss here on statutory grounds. And they're going through here and talking a lot about the Fisher case, which I think is very important. It was a case decided by the U.S. Supreme Court within days of the immunity case. I think Fisher came down, and then a few weeks later, the other case came down. So Jack goes into how 1512C1, which is what Mr. Trump has been charged with, how it is properly applicable here. So I think he's done a good job writing it out and how this is an appropriate situation for the superseding indictment. That is on file now. Now, I'm not going to spend a lot of time with that tonight. I do want to go through it. But what I really want to make sure I share with everyone is the order that just came down. So both of these were filed today, and Jack's hit the docket first as document 262, and then this is document 263, which is the order. So this order does not address what he says in his motion. So what I'm going to do is just kind of wait until we've got the other side stepping in when it comes to that particular motion. So, I know, right? I know. So I'm glad to be back too, Liz. I'm very glad to be back. So I want to take you through, again, it is a 50-page order tonight, and I have gone through it, and I think this is a great place to just kind of remind everybody of what's happened in this case before it went up to the Supreme Court. So we probably won't make it through the entire order tonight, but I think it'll give you a good idea of what's going on in DC right now, so that every single time she does an order, Judge Chutkan realizes that this could be the one that goes all the way up to the Supreme Court again. And we're going to kind of have this back and forth situation occurring depending on how lenient the Supreme Court wants to be and how they deal with the situation compared to how they deal with all the other situations with all the other people. So we will see how it goes. Yes, I am doing well. Thank you. Oh, I'm so glad to be back, everybody. So glad to be back. Very, very glad to be back. So we've got here. Oh, I'm so glad. Oh, you're so sweet. No, I'm really, really excited to be back. So yes, I am recovering. I'm doing much better now. So I'll go ahead and dive on in, everyone, because we do have quite a few pages I want to make it through, and I don't want to be going too fast. I've noticed recently I've started talking faster because I'm worried my time will run out, so I need to kind of slow it down a little bit. But this should be pretty good. Yep, got it right here, Deb. Look at that. I beat you. I've got it right here just for you. So, and anyone else? Yes. Is the old schedule on? Oh, I'm not sure. I've kind of had to rearrange some things. I don't have a set schedule quite yet, but I will be getting one up and running. Do you have your tea ready? I do. I do have my tea ready. Do you think Supreme Court is trying to be careful since they're under scrutiny? I think so, to some degree, but again, it's hard to know with a Supreme Court that doesn't seem to follow, you know, what you're supposed to do. So that's kind of a hard thing. But I was worried it might wear your voice out. Oh, Thomas, that's so sweet. No, I had just, it's hard for me to get used to being back up and around. We'll say that. I've been in a bed for about 10 days, not getting out of the bed. So to be up again, I have to pace myself. I'm so excited about it. So I've got to watch it a little bit. But let me go ahead and dive in. Again, this is document 263. It is available online. This is the case number here, again, for the DC case. This is the order that was issued, and it was issued today and by Judge Chutkan. So that's where we will go ahead and dive right in here. So memorandum, opinion, and order. Defendant has filed a motion to compel discovery and a motion for an order regarding the scope of the prosecution team. Collectively, the motions seek an order requiring the prosecution to search 9 government entities for 14 categories of information and to produce any discovered information to the defense. For the reasons set forth below and in a classified supplement that will be distributed to the parties, the court will grant in part and deny in part defendant's motions and require defendant to file any further motions to compel immunity-related discovery by October 30th. All right, so we've got a partial one way or the other here. So we'll start off with the background. A, discovery obligations. As relevant here, the government must comply with 2 related discovery obligations. And then here's our footnote 1. The court may refer to the government as the special counsel's office, the office, or the prosecution. First, it must search for and produce Brady materials. Quote, the suppression by the prosecution of evidence favorable to an accused upon request violates due process, where the evidence is material either to guilt or to punishment. We're citing that Brady case here. And remember, the Brady rule will play a significant role in all of these cases. The court shares the view of others in this district in order to minimize the risk of any such due process violation. The court has an affirmative duty during all phases of a criminal case to produce any potentially exculpatory or otherwise favorable evidence without regard to how the withholding of such evidence might be viewed, with the benefit of hindsight as affecting the outcome of trial. That includes all favorable evidence that is itself admissible or that is likely to lead to favorable evidence that would be admissible or that could be used to impeach a prosecution witness. Impeaching means to go after the credibility of a witness that you did not call. So other party calls a witness in, you go in on cross-examination. What you're doing is you're trying to impeach them. So that's what that means there. Brady also imposes a duty to learn of any favorable evidence known to the others acting on the government's behalf, in the case including the police. That includes a duty to search files maintained by branches of government, closely aligned with the prosecution, if there is enough of a prospect of exculpatory materials to warrant a search. The scope of that duty depends on the working relationship between the prosecution and other agencies, along with the nature of the files at issue, the difficulty of searching for them, and the prospect of finding favorable evidence therein. And then she's citing the Brooks case and the Griffith case, saying, finding no Brady obligation where there was no sound basis for believing that the records contained potentially exculpatory material and the documents were not within the control of the prosecutors or another government office that would allow the prosecutors easy access. The burden of showing a Brady violation is on the defendant. So I think that's really important. If they're saying there's a violation on any of that exculpatory evidence, the burden goes to the defendant. Defendant has to show that to the judge. That showing must identify withheld evidence, material and favorable to his defense in ways not cumulative. Mere speculation, either that another agency is closely aligned with the prosecution or that a search of its files would yield favorable evidence, cannot support a claim that the prosecution has failed to fulfill its Brady obligations. And as the burden of the proposed examination rises, clearly the likelihood of a payoff must also rise before the government can be put to the effort. In the typical case where a defendant makes only a general request for exculpatory material under Brady, it is the state that decides which information must be disclosed. Unless defense counsel becomes aware that other exculpatory evidence was withheld and brings it to the court's attention, the prosecutor's decision on disclosure is final. And then we've got footnote here, number 2. In preparing a defense, defendant is not confined to the materials disclosed by the prosecution. He may gather evidence through his own investigation, including by issuing subpoenas as are appropriate. So she's reminding him, you can do your own research also, sir. Second, the government must produce certain documents if requested by the defense. Federal Rule of Criminal Procedure 16A1E provides, upon a defendant's request, the government must permit the defendant to inspect and to copy or photograph books, papers, documents, data, photographs, tangible objects, buildings or places, or copies or portions of any of these items if the item is within the government's possession, custody, or control, and the item is material to preparing the defense. So that's our rule. Rule 16. Go. As set forth below, the legal standard governing the prosecutor's Rule 16 obligations mirror in large part the standard under Brady. Defendant's Rule 16 request obligates the government to search its files for and produce evidence material to his defense. Defendant bears the burden of demonstrating that materiality under Rule 16. While it is not a heavy burden, he must point to at least a strong indication that the requested information will play an important role in uncovering admissible evidence, aiding witness preparation, corroborating testimony, or assisting impeachment or rebuttal. In other words, the government need disclose Rule 16 material only if it enables the defendant significantly to alter the quantum of proof in his favor. When analyzing materiality, a court should focus first on the indictment, which sets out the issues to which the defendant's theory of case must respond. To compel Rule 16 discovery, defendant must show at least a tenable relationship between the materials sought and the preparation of the defense to those allegations. So there's got to be some connection. We can't just dive in and say, well, we think there's stuff out there. You actually have to show that there's stuff out there that could assist you. Rule 16 limits the government's duty to search for or produce requested evidence and information within its possession, custody, or control. In determining the scope of that control, courts have in the main been more concerned with fairness to the defendant on the one hand and the government's case of access to the documents sought on the other hand than with the issue whether the documents are actually within the physical possession of the prosecutor. Accordingly, judges in this district have applied the same definition of control that governs Brady obligations. A prosecutor must search for and produce information maintained by other components of the government which are closely aligned with the prosecution. The closeness of any such alignment is fact-intensive and must be resolved on a case-by-case basis. Oh no, a sticky note. Thank you, apologize. Yes, I'm a bit rusty, everybody. Bear with me. Bear with me. All right, B, defendant's motions. So this, again, is what he has filed before and is now saying, this is what I'd like to have on the docket now. So defendant contends that the government has failed to comply with its discovery obligations under Brady and Rule 16. Specifically, the motion to compel cites defendant's discovery request to identify 14 categories of information that he argues the government has unlawfully failed to search for and produce. Defendant's accompanying motion on scope asserts that the prosecution must search for the requested information, along with all other Brady, Giglio, and Jenks Act materials, not only in the files held by the prosecutors of the special counsel's office and law enforcement officers who were working on the case, but also in the files of 9 additional government entities. Although his arguments span 2 motions, defendant effectively pursues a single form of relief, an order from this court compelling the government to search the additional government entities and produce all the information to which defendant believes he's entitled. Relying on the Department of Justice's internal policies, defendant contends that the search should include a review of any relevant files at law enforcement agencies that may contain discoverable information, spanning the investigative agency's entire investigative file, including documents such as the FBI electronic communication inserts, emails, and substantive case-related communications. So he's not asking for much, just everything. It likewise contends that the government should conduct prudential search requests at agencies and components that may possess discoverable materials. Whether under Rule 16 or Brady and its related obligations, the government's duty to search for and produce information is bounded by 1, the materiality of the information, including its favorability for the defendant, and 2, the government's control over that information. In reviewing a Brady challenge in U.S. v. Haldeman, the D.C. Circuit explained that it was only necessary to define the scope of the prosecution team if the defendant had carried his burden of showing that the information he sought was material. So she's setting out here that in D.C., you've really got to show something. You can't just throw it up against the wall. You've got to actually show that there's something that's going to be material here. Accordingly, the court begins by assessing what information the government is obligated to search for and then determining where the government must search for it. As noted above, the materiality analysis at the heart of that assessment starts with the indictment. Defendant's motion to compel and motion on scope were filed before the superseding indictment, but his reply in support of those motions was filed after it. The court accordingly addresses defendant's motions and arguments as applied to the superseding indictment's allegations. Materiality. So this is where she's going to determine whether what he's asking for is material or not. And if it's not material, then she does not need to order the government to do anything. So materiality. 5 of the 14 categories of information defendant seeks specifically request discrete identified documents. The remaining 9 categories are generic requests for all information or evidence relating to certain topics. As explained below, defendant has only carried his burden with respect to a small portion of the information he seeks. For most of it, he has proffered only speculation that a search will yield material, non-cumulative information. Moreover, while defendant purports to seek much of that information to show his state of mind at the time of his indictment conduct, his good faith and the absence of criminal intent in disagreeing with officials now favored by the prosecution and relying instead on his independent judgment that the election was stolen. He does not indicate that he was aware of the requested information such that it could have affected his state of mind. And then she's citing here a U.S. v. Secord. To affect defendant's state of mind, his specific intent, a piece of information must have been perceived by him personally or been conveyed to him via his contacts in the executive branch. Consequently, with few exceptions, the court cannot compel the government to search for or produce additional documents. So she's already saying you're not going to get everything that you're asking for here. But let's take a look at those 2 that are potentials. So identify documents. Now we're going to go through each of these documents one at a time. There's a lot of information in here about these documents, everyone. Some information you may not have heard of before. Here we go. Identify documents. Number 1, 2016 election ICA records. First, defendant seeks a complete classified version of the 2016 election ICA intelligence community assessment and all source materials. assessing Russian activities and intentions in recent U.S. elections, the analytic process in the cyber incident attribution. Again, we're citing this here. Declassified version, 2016 election ICA. He claims that information relating to a significant escalation of foreign influence in the 2016 election motivated him and his administration to focus on foreign influence and cyber risks, rebutting the allegation that his actions between November 20th and January of 2021 were motivated by a desire to maintain office and undertaken with specific intent and unlawful purpose. All right, everybody, this is Mr. Trump's defense. All right, if you're going to wonder what his defense was going to be, this is it right here. This is going to be his defense at trial. All right, he's going to say the reason why he did what he did was because he was afraid of foreign interference, and that's his job as the president, to make sure that foreign interference doesn't mess with the United States. So this is going to be his main defense. So that's incredibly helpful. We've heard pieces of it, but we haven't heard it completely fleshed out until now. Yeah, so that's his full defense. And he contends that the 2016 election ICA contradicts the allegations that he eroded public faith in the administration of the election by disclosing foreign efforts to accomplish that erosion. The government replies that the classified 2016 election ICA is immaterial because it relates to a different election, and the defense seeks closely guarded secrets of national security about the illicit activity of actors who are not implicated in the indictment, and that there is no meaningful connection between the charges in the indictment and the specific information relating to measures defendant oversaw to mitigate cybersecurity threats. Defendant has not carried his burden to establish an adequate basis for inferring that the requested documents will contain any material information. He already has access to unclassified public versions of the 2016 election ICA, and its conclusions are identical to the highly classified assessment. Cumulative information generally does not enable the defendant significantly to alter the quantum of proof in his favor. So she's saying you already have access to what you need, and so often does not qualify as material. So we're citing some case law here. Information in the other redacted portions of an SRT report is cumulative and not material under either Brady or Rule 16. And she's citing another case here, doing kind of the same thing. Defendant does not demonstrate the additional classified materials he seeks will be non-cumulative or otherwise material. Can the government cite the Mueller report? Absolutely. Absolutely. Tea break. Thanks, Deb. Yeah, they can. But you got to make sure you don't lose your jury, right? So if they're filing motions and different things, citing the Mueller report, that's fine. But if you start bringing that out and trying to give any of that information to the jury, well, first you'd have a hearsay issue, but you could overcome that. But our juries don't like that kind of stuff. They're like, we're not going to read a 1,000-page report, dude. So we try to keep it from our jury, but we can absolutely use it in our filings. Defendant does not demonstrate that the additional classified materials he seeks will be non-cumulative or otherwise material. A motion to compel must give some reason to believe that the requested search and production will yield material fruit. Mere speculation that a government file may contain something helpful is not enough. Now, here, when we're saying cumulative, we're just saying repeatedly or multiple copies of the same thing. Furthermore, defendant fails to explain how classified records related to the 2016 election ICA could bear on his motives for acts he allegedly committed years later. Courts have routinely explained that information to which the defendants were not privy would be entirely irrelevant to their state of mind. And then she's citing the Sturgeon case here and the George case, where finding information immaterial for purpose of a defendant's intent unless the defendant was aware of it. Also, a second cite here, similarly requiring a defendant to have personally perceived or been provided information for it to be material to his state of mind. So she's saying if he hasn't seen this stuff, then it's not going to be material. Defendant does not claim to have reviewed the records he seeks, their sources or their conclusions, before or during the time period of his indicted conduct. nor does he proffer that the information therein was relayed to him by someone else. There is no basis accordingly for the inference that classified portions of the 2016 election ICA contain intelligence that underscores his good faith in undertaking that conduct. Motion to compel at 22 is specific here, and no reason to consider them material on that basis. So she's saying, no, you cannot have access to this that you're asking. So the second piece here, we have the 2020 election CISA statement records. Second, defendant seeks information that undercuts the categorical claims in the 2020 election CISA statement. In particular, drafts of that statement that contain narrower language and communications relating to revisions. And here we're just citing where it came from out of CISA. The superseding indictment refers to that statement in alleging that the 2020 election was the most secure in American history, and that there was no evidence any voting system deleted or lost votes, changed votes, or was in any way compromised. Defendant contends that the records he seeks will bolster his argument at trial that the 2020 election CISA statement was part of a partisan effort to provide false assurances to the public that outpaced the government's understanding of the situation. All right, so this is important, everybody. This is part 2 of his defense. He's going to say that any information saying that there was nothing wrong was because it was part of a plan. So we'll call this the conspiracy element to his defense. Oh my gosh. That's something special right there. Oh my goodness. All right, here we go. As with his first request, however, defendant presents nothing more than speculation that any earlier drafts and communications about revisions of 2020 CISA statement will undermine its final conclusions. His only attempt at doing so is to reference to the solar winds sunburst attack. Relying on the allegations in another case's civil complaint, defendant reports that in 2019 and 2020, parties reportedly linked to Russia's foreign intelligence service, inserted malicious code into it, certain software products, and conducted reconnaissance, exfiltration, and data collection that posed an unacceptable risk to federal civilian executive branch agencies. Ooh, goodness gracious. Goodness. Defendant claims that the solar winds attack renders the 2020 election CISA statement's conclusions implausible, but he identifies no link between the solar winds attack and the compromise of any election systems, or even the 2020 election in general. Consequently, there is no indication that the statement's revisions or communications about them would be favorable to defendant or otherwise material to preparing his defense, and the government has no obligation to search for or produce them. This request also lacks a link to defendant's mental state. Presumably, defendant seeks to characterize the 2020 election CISA statement as partisan to rebut the superseding's allegation that he claimed election fraud were unsupported and objectively unreasonable and publicly disproven. But at the time of his indicted conduct, defendant would only have had reason to believe the statement was partisan if he knew about the information like that he requested here, such as earlier, narrower drafts or communications that undercut the categorical claims therein. So she's saying he would have even had access to this before. Had defendant proffered, for instance, that he had seen or been told about narrower drafts of the statement before his allegedly criminal activity, that could render those earlier versions material. But he has not made that proffer or anything like it, much less supplied a strong indication that the requested records could have given him reason to doubt the statement's conclusion. Accordingly, he has not established the materiality of the 2020 election CISA statements, early drafts, or revision communications. So he is not entitled to that compel statement. Let's see. Number 3, 2020 election ICA records. Third, defendant seeks four specific types of records relating to the 2020 election intelligence community assessment, so ICA. Here it says, and we're on EC 167-6 classified version. Specifically, he requests, so this is what Mr. Trump's asking for here. 1, all drafts of the 2020 election ICA. 2, communications regarding drafting and revisions. 3, all information and material relating to Dr. Zulof's conclusions, including evidence of efforts by CIA management to pressure analysts and suppress reporting. And 4, the additional materials discussed in the classified supplement. Defendant hangs the materiality of those records on the original indictment's reference to the intelligence community findings from the 2020 election ICA. He contends that all information that is inconsistent with the judgments in the ICA favors the defense and makes the requested records material. And we're citing here section 2B5 through 6, discussing broader requests for all information regarding foreign influence and interference in the 2020 election, which overlaps somewhat with this category. Specifically, defendant argues that the records are material because they can be used to impeach the 2020 election CISA statement and the ICA's judgments, to argue that he and others had greater concerns about the integrity of the election than the witnesses that the prosecutor prefers, and to impeach anticipated testimony from former CISA director using information relating to the Sunburst attack. I don't know who Zulu is. I don't know. Is that a Star Trek character? I'm not sure. Oh my goodness gracious. So basically he's saying we need information to show that there's a conspiracy. Can you give us the information that shows that there's a conspiracy involved? Because that's what we think happened. Even as applied to the original indictment, these arguments are flawed. To begin, the logical chain between these requested records and defendants' concerns about the integrity of the election, again, lacks the crucial link. Defendant's awareness of the records. He does not indicate that he knew about these records or their contents, and so they could not have informed any concerns that he had at the time. By the same token, these records can only impeach the 2020 election CISA statement and the ICA's judgment to the extent that they contradict defendant's alleged state of mind. Oh my gosh, yes they do. It's all for my poor printers that are my best friends. I have 2 and they're very thankful for ink. That defendant knew that his claims of election fraud were false. So this again is that second part of that defense he's putting on. And the records could not have affected his state of mind if he did not know about them. So he's asking for records he didn't even know existed at the time in order to establish the state of mind that he had at the time. Finally, defendant proves no reason to believe the requested records in this category contain information relating to the Sunburst attack that could be used to impeach anticipated testimony from the former CISA director. Remember that CISA director was filed by Mr. Trump. That was a big piece in the indictment, that as soon as he had told Mr. Trump there was no fraud, Mr. Trump had then fired him. As noted, a defendant's motion to compel cannot succeed if based solely on the desire for information and speculation that the records sought may contain it. The superseding indictment offers even less support for defendant's arguments about materiality. Unlike the original indictment, it does not rely on allegations about intelligence community findings to establish his state of mind. So the 2020 election ICA records are correspondingly less relevant to that element. Defendant offers an alternative ground for their materiality, contending that the records could support his presidential immunity defense because they relate to his role as commander-in-chief overseeing intelligence gathering. So everyone, this is going to be a third piece of his defense here. All right. So this is also important. This is what we're going to be diving into if we ever get to trial in this case. These are going to be his theories. That he did what he did because he had to as the commander-in-chief because he was worried about foreign influence in the election. That is his defense. But defendant is not charged with unlawfully gathering intelligence. Oh, thank you so much. And he does not explain how that role is implicated by any of the criminal conduct alleged in the superseding indictment and could thus be a defense for it. The court therefore cannot compel the records on that theory either. In addition, defendant does not indicate that the requested records contain material information beyond what he has already received. The government reports that in addition to the public declassified 2020 election ICA, defendant has already received 2 classified versions, the final draft and an earlier draft. Defendant gives no basis for the inference that other data or communications about revisions would contain favorable or otherwise material information. He cites the 2020 election ICA's minority view, which suggests that China took at least some steps to undermine President Trump's re-election chances, meaning the definition of election influence, but not that China tried to interfere with the election processes. Interesting. Accordingly, the minority view does not indicate that the 2020 election ICA's earlier drafts of the revision communications contain information supporting defendants' election fraud claims. The same is true of the records related to the public report from the intelligence community analytic ombudsman. I can never say that right. Mr. Zuloff. Oh, there's Dr. Zuloff. There we go, everybody. He's the ombudsman. Defendant focuses on the report's comments on efforts to suppress alternative analysis about China's attempt to conduct election interference. But he draws no connection between those efforts or that alternative analysis, and this case, much less, explains why he needs classified information and materials relating to them. The report itself notes that the efforts took place before the charged conduct in this case, and that the alternative analysis itself was ultimately published. This was already available to the public. He already has all the information. That's what the judge is saying here. Without more, the court cannot conclude that the 2020 election ICA records are material to the preparation of a defense. So she is saying, no, you may not have that because you should already have it. So number 4 here, ombudsman. Thanks. It's a tough one. I think I just mentally already know it's going to be a tough word, so I freak myself out about it. All right, number 4, 2020 election DOJ DHS report. 4th, defendant requests the complete classified version of the 2020 election DOJ DHS report and all source materials. So this would be motion to compel at 26. So Department of Justice, Department of Homeland Security, here, foreign interference targeting election infrastructure or political organization campaign or candidate infrastructure related to the 2020 U.S. federal elections. And this was dated March of 2021. The report found no evidence that any foreign government affiliated actor prevented voting, changed votes, or disrupted the ability to tally votes or to transmit election results in a timely manner, altered any technical aspect of the voting process, or otherwise compromised the integrity of the voter registration information of any ballots cast during the 2020 federal election. Despite this finding, defendant argues that the report's classified details will support his defense that he had good faith concerns about the integrity of the election. But while the defendant cites snippets from the report indicating that its authors considered several potential threats to the election's integrity, he omits that the report refused them all. For example, he highlights several incidents when Russian, Chinese, and Iranian government affiliated actors materially impacted the security of networks associated with or pertaining to U.S. political organizations, candidates, or campaigns during 2020 federal elections, and broad Russian and Iranian campaigns targeting multiple critical infrastructure sectors did compromise the security of several networks that manage some election functions, but ignored that those efforts did not materially affect the integrity of the voter data. So he's kind of just cherry picking what he wants out of that report and not getting the full context. And the judge is saying, if you look to the context, you can see that there's no, what you're looking for is not there. All right, so 13, affect the integrity of voter data, the ability to vote, the tabulation of votes, or the timely transmission of election results. Likewise, defendant relies on the report's acknowledgement of multiple public claims that one or more foreign governments manipulated election infrastructure or vote counts, despite its author's statement that they had investigated the public claims and determined that they were not credible. Defendant does not offer anything beyond speculation that the report's classified details will, contrary to its publicly stated conclusions, reveal any threats that actually impacted the election's integrity. The larger problem with this request, though, is that once defendant has not proffered any indication that the report's classified details could have affected his state of mind during the alleged offenses. He argues that he was not obligated to credit the report's assessments and determinations at the time. That may be true, but the information defendant now seeks could not have prompted him to discredit those assessments unless he knew about them during the relevant time period, and he does not make that claim. Instead, he argues that he must be permitted to draw attention to good faith, non-criminal disagreements regarding the purported conclusions that the special counsel's office seeks to present as infallible. But whatever disagreements other people may have about those conclusions, they are immaterial to this case unless they concern a specific element of the offenses charged, such as the defendant's intent. Indeed, even the original indictment did not refer to the intelligence community's findings regarding foreign intelligence as infallible per se, but rather as evidence that defendant knew that his claims of election fraud were false, because he was notified repeatedly that his claims were untrue, often by the people on whom he relied for candid advice on important matters and who were best positioned to know the facts. So this is going to be the counter argument of the government, everyone. So this is going to be the government's theory of the case here. So before we had what the defense was going to put in, now we have how the government's going to fight that back. They're going to say, you had all of this information. You knew. So your mindset was already there, was already taken care of. As already noted, the superseding indictment does not refer to those findings at all, instead alleging defendant's knowledge based on information he received from his own running mate and his campaign staff, along with state officials in other organizations. Defendant has given no reason to believe that the report's classified details would assist him in preparing a defense against the allegation that his subordinates provided him contrary information and counsel based on classified details he seeks. Without a connection to that defense or some other one, the report and its classified sources are not material. So a good way to kind of figure out what she's saying here is to replace the word material with relevant. All right, so they're not relevant to the case. So she's saying no on that one as well. You do not get to have that one either. Here we go. Number 5, the D&I interview preparation materials. 5th, defendant seeks records related to the testimony of a former director of national intelligence. So that's the D&I. The original indictment alleged that the D&I disabused the defendant of the notion that the intelligence community's findings regarding foreign interference would change the outcome of the election. Defendant notes that during an interview by special counsel's office and related grand jury testimony, the D&I indicated that he had prepared by reviewing materials maintained by his former employer, the Office of the Director of National Intelligence. Defendant argues that therefore the government must collect and produce all such materials, along with all classified communications relating to the subject matter of the D&I's testimony. While the superseding indictment does not contain the same allegations about D&I's communication with the defendant, the government has not disputed that the D&I is a potential witness in this case, although it maintains that defendant has not shown that any of the information in those records would be material. The government may have a duty to search for and produce these records if they are within its control. Documents that informed a prospective witness's testimony may be relevant for impeachment purposes, as well as subject to disclosure under the Jenks Act. which requires the government on a motion of the defendant to produce any statement of a witness in the possession of the United States which relates to the subject matter of their testimony. If the materials the DNI reviewed before his interview included some of his own prior statements and relate to his testimony, which seems likely given he was preparing to speak about his own past conduct and recollection, the Jenks Act may obligate the government to produce any of those statements in its possession. The obligation does not formally trigger until after the witness has testified on direct examination in the trial of the case. But in the interests of justice, courts have sometimes ordered the government to produce Jenks Act material in advance of trial. And she's citing a case here. Consequently, the court is persuaded that the nature of the files triggers the duty to search for them. The question of where the government must search for these materials is discussed in Section 3. As defendant's motion itself suggested, many of the materials appear to be maintained by ODNI, which the court does not consider to be part of the prosecution team. And so a search of the prosecution's records may be unlikely to bear fruit. The court will also afford the government an opportunity to argue, should it choose to do so, why it's not required to produce Jenks Act material until trial. So this is the only one where she's saying we may have a bit of an issue here. We may need to pull whatever files this witness used to refresh his memory when he was testifying to the grand jury. So this one's a maybe. All of the others are no's, but this one is a maybe for sure. Next up, generic requests. So this was kind of what she was hinting at before when she's saying you can't just throw everything up against the wall here. That's what these generic requests are meaning. Number 1, January 6, responsibility statements. Defendant seeks all documents, including private communications, in which prosecutors, law enforcement, and other officials made statements that are inconsistent with prosecution's position regarding responsibility for January 6th. And then we have a footnote here after the motion to compel. Number 3, it says, in his reply, defendant reframes this request as all statements by officials that are inconsistent with the office's theory of the case. This is a much broader category, and like asking for all Brady material or anything exculpatory, really gives the prosecutor no better notice than if no request is made. The court accordingly focuses its analysis on the request as stated in the motion to compel. So she's saying, again, this is too broad of a request that you're making here. The government position to which the defendant refers to is that the defendant's responsible for the events at the Capitol on January 6th, a day that was the culmination of the defendant's criminal conspiracies to overturn the legitimate results of the presidential election. Defendants view that position is contradicted by statements by prosecutors from the United States Attorney's Office for the District of Columbia, which makes those statements exculpatory under Brady because they undercut one of the prosecution's arguments. In theory, inconsistent statements by government officials might be admissible as an opposing party statement under Federal Rule of Evidence 801D2, which is a hearsay rule. 801 and 802 are hearsay, 803 are the exceptions. To support the inference that such inconsistent statements exist and must therefore be searched for and produced, defendant points to several examples from the prosecutions of January 6 rioters. A prosecutor's argument that a defendant could not assert an entrapment by estoppel or public authority defense because he could not identify any remarks made by former President Trump that authorized the illegal conduct. And she's citing the Carpenter case here. A prosecutor's closing statement that it is essentially irrelevant in this case what you think about President Trump's conduct on that day, end quote. And we're citing the Thompson case. And a prosecutor's statement that the president didn't take action in the days leading to January 6th, citing the Rhodes case. It does not appear, however, that these kinds of statements could assist defendant significantly to alter the quantum of proof in his favor. Opposing party statements from government agents are relevant only to the extent that they make the existence of a material fact more probable or less probable than it would be without the evidence. And that is our standard for relevance. And this would be in Rule 401. If you're looking for that, and we're citing the Morgan case here. District Court erred in excluding a sworn affidavit from the detective stating that an informant was reliable. Citing Warren, District Court erred in excluding a sworn affidavit from a police officer stating that someone besides the defendant leased an apartment where bad things were found. The USAO DC prosecutors whose statements defendant seeks were not fact witnesses in the January 6 rioter case, nor does he suggest that their statements reflect personal knowledge that could be admissible against the government as substantive evidence in this case, citing Morgan again. Defendant has thus failed to show that the statements could be exculpatory. In any event, the court is not persuaded that the USAO DC prosecutor statements actually contradict the government's position in the case. It is entirely conceivable, for instance, that defendant could share responsibility for the events on January 6th without such express authorization of rioters' criminal actions, that they could claim entrapment by estoppel or public authority defenses, citing Carpenter. Likewise, defendant could still share the responsibility even though he did not take certain actions that some rioters had hoped for, i.e. invoking the Insurrection Act to stop the election, to call up the military and groups like the Oath Keepers, to seize voting machines, to throw out the results, and to hold a new election. Wow, that's awful. Oh my gosh. Nor is there a contradiction in a prosecutor stating that defendant's conduct was essentially irrelevant to January 6 rioters' case. And then we're citing the case Thompson here. As the government has explained, its position in other January 6 cases that the defendant's actions did not absolve any individual rioter of responsibility for that rioter's actions, even if the rioter took them at the defense's direction, is in no way inconsistent with the indictment's allegations here. So they're saying if you're a rioter and you're depending on that statement of, thank you very much, Seuss, and you're depending on saying, well, Mr. Trump told us to do it, that's not going to help you in your case. All right, next up. So that's the first piece, the January 6 responsibility statements. Number 2 is January 6 security. Next, defendant seeks all information relating to security at the Capitol on January 6th, including documents and communications regarding requests for security and timing of the National Guard's deployment that day. He originally argued that the information is material because it suggests that 1, federal and local officials believed adequate measures were in place to facilitate a lawful and peaceful protest at the Capitol, including during the speech at the Ellipse, and 2, the delayed arrival of the National Guard contributed to the violence that he sought to prevent. And he noted that there are public records of a number of meetings from Saturday, January 2nd through Monday, January 4th of 2021 within the Departments of Defense, Justice, Homeland Security, and Interior regarding security at the Capitol. With one narrow exception, the court is not persuaded that the defendant has adequately demonstrated the materiality of this information on those grounds. To begin, defendant has not given sufficient indication that all information relating to security at the Capitol of January 6th, sorry everyone, puzzle piece, one moment. Did we pass? Yes, we passed. Okay, yay, here we go. To begin, defendant has not given sufficient indication that all information relating to the security at the Capitol on January 6th will be material to the preparation of his defense. As discussed above, he primarily seeks discovery to support the defense that he genuinely believed that the election was stolen, and related arguments regarding good faith and the absence of criminal intent. So again, we've got that key piece to what he is arguing for his defense. I think it's very helpful to pull out what they're going to be using as arguments in their case, because we can always refer back to it. So this again goes to what his defense is. He's arguing he had a good faith belief that the election had been stolen, and so he did what he did because of that. With respect to the events on January 6th, that defense might include security measures that informed President Trump's remarks and assessment of the situation. But defendant's request is not limited to those measures. Instead, he claims to be entitled to not only information relating to events and communications in which he participated, but also interactions in which he was not directly involved. He does not explain that entitlement other than by citing Safavian, which found a discrete set of emails that the defendant had not seen to be material because they could support a defense unrelated to the defendant's state of mind. So state of mind is going to play such a huge role, everybody, as the intent level in this case, right? So we've talked about this before. You have to have an act plus an intent in order to have a crime. So that second piece, this intent piece, his state of mind, is going to be what makes or breaks this case. That's what the prosecution will have to figure out how to show properly that he knew what he was doing and he did it anyway, that it wasn't just good faith belief, it was something else. There was a malicious belief here. So this will be the key to this case. Here, however, defendant's not identified an alternative defense for which the wide range of information he seeks could be material. So let's flip to the next page. I know I've skipped past this footnote here, but I think we'll be all right. 22. Moreover, defendant makes no effort to distinguish between the information he already has and that which he still needs. Cumulative information is generally not material, and the government indicates that the defendant has already received considerable discovery related to security at the Capitol on January 6th. Courts disfavor overbroad requests. Without a more specific showing of what information defendant still needs and why he needs it, the court cannot order a search for all information relating to the security of the Capitol on January 6th. As noted, there is one exception. Defendant cites a public report that includes General Mark Milley's recollection of a meeting he had had a few days before January 6th with defendant and Acting Secretary of Defense Christopher Miller. According to the report, the meeting's primary topic was unrelated to the scheduled rally, but at the end of the meeting, the president told Mr. Miller that there would be a large number of protesters on January 6th of 2021, and Mr. Miller should ensure sufficient National Guard or soldiers would be there to make sure it was a safe event. Mr. Miller responded, "We've got a plan and we've got it covered." So that is, again, they're citing that here. So we've got a footnote to that citation that's saying, here's a link where that's available. This meeting could have affected defendant's state of mind during the relevant time period, and its contents would thus be material to the defense. Defendant does not specify whether he needs additional information specifically regarding the exchange he had with Acting Secretary Miller during the meeting, but the government does not mention anything related to it in describing the records defendant had already received. The court will therefore give the defendant the benefit of the doubt and assume that any additional information would not be cumulative. Accordingly, the court will order the government to search for and produce any additional records within its possession concerning information about security measures that was conveyed to the defendant during his meeting with General Milley, the Acting Secretary Miller, and Acting Secretary Mueller. So what she's saying here is, if any information was given to Mr. Trump in this situation, any of that does need to be shown to him. He does have a right to have that if there is information. But again, we don't know. We don't know if there's information on that or not. Beyond the points above, defendant adds that security-related disclosures are discoverable, irrespective of his knowledge, because these materials provide relevant context for determining the scope of official acts and dangers of intrusion on the executive branch for purposes of presidential immunity. So he's saying, well, even if I wasn't involved, everything going on around me is covered by that immunity decision, so you have to give it to me anyway. But he does not elaborate on that conclusion by explaining how all materials related to security would provide relevant context for determining the scope of official acts, which allegations they would contextualize, or how they would implicate the potential dangers of intrusion that this prosecution could pose for the executive branch. Defendant bears the burden of justifying a court order compelling discovery, and broad gestures of context are not sufficient. Without a clearly identified and sufficient nexus to the superseding indictment's allegations or particular immunity arguments, there is no basis for ordering specific disclosures at this juncture. So she's saying no on this. And this one is like, well, look and see and let me know if you have anything. Right. All right, January 6th, federal agents. Defendant also seeks all information regarding undercover agents and individuals acting at the direction of official authorities at the Capitol on January 6th. He argues that information regarding individuals who were present in an official capacity is favorable to him because it suggests that there were adequate controls in place, that the violence at issue resulted from a failure of those controls and or failed sting operations rather than any directions from him. So here's another one of his major defenses, everyone. All right, so let's take a look at that. He's going to say, as another defense, that the security failed. It wasn't him, it was the security. So that's a classic defense strategy. It wasn't me, that person did it. So he's putting that blame onto someone else to show that, well, again, it's not my fault, it's their fault. And that's a classic technique that we use as criminal attorneys. The court cannot agree that this information is... hold on. Was it is? 23, 24. Sorry. The court cannot agree that this information is material. And flip the page. As with his broader request regarding all security measures at the Capitol on January 6th, defendant omits any connection between the information he seeks and his state of mind, whether there are adequate controls in place and that the violence at issue resulted from failure of those controls could only have supplied the good faith that defendant intends to assert if he knew about those controls at the time, and he does not proffer that he did. The only case defendant cites in support of this request, U.S. v. Zink, rejected a January 6 rioters' request for the identification of any and all undercover government agents who may have been present at the Capitol on January 6th for the very same reason. There was no sign that any of those purported actors could have affected or did affect the rioters' conduct or state of mind. And like in Zink, defendant does not provide anything more than speculation that there even were such undercover actors at the Capitol on January 6th. Consequently, there is no reason to compel the government to search for and produce that information in this case. Tea break. All right, number 4, foreign influence. Now, again, I'm not going to be able to make it through this entire order tonight, but I would like to make it through these last documents that she's talking about here. Number 4, foreign influence. Perhaps the largest category of discovery that defendant seeks is to compel all information relating to foreign influence efforts targeting the 2020 election, including foreign influence relating to events on January 6th, whether or not he was briefed contemporaneously regarding these issues. He asserts that this information is material under 2 theories. 1, it rebuts the allegation that the defendant created an intense national atmosphere of mistrust and anger and eroded public faith in the administration of the 2020 election. And 2, it supports the defense argument that President Trump and others acted in good faith if certain reports were ultimately determined to be inaccurate. To bolster his claim that such information has not yet been produced, he cites the 2020 election ICA and the report issued by the House Select Committee to investigate the January 6th attack on the United States Capitol. Defendant's theories of materiality do not withstand scrutiny. The first relies on a misunderstanding of the charges against him. Oh dear. That's harsh. That's pretty harsh, Judge Chutkan. I'm going to highlight that just for fun. I'm going to highlight this one just for me. That's pretty bad. Oh my goodness. Oh my goodness gracious. That's really bad. All right. Yeah, you don't ever want to see that in an order. Oh, yikes. All right, the superseding indictment does not allege defendant's criminal activity to be that he created an intense national atmosphere of mistrust and anger and eroded public faith in the administration of the 2020 election. Indeed, it stresses that defendant had a right to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election that he had won. And it identifies where defendant's conduct crossed the line. In addition to whatever effect those claims had on the national atmosphere, defendant also pursued unlawful means of discounting legitimate votes and subverting the election results. Those unlawful means, read it again. All right. Hold on, let me finish the paragraph. Those unlawful means are crimes with which defendant is charged, including several criminal conspiracies. All right, let's go back up. I'll just make a note. All right, this is cracking me up, everybody. It's cracking me up. Here we go. Here's what's is very interesting. Defendant's theories of materiality do not withstand scrutiny. The first relies on a misunderstanding of the charges against him. So she's saying, Mr. Trump, you don't understand what you've been charged with. And then she proceeds to explain it. This is what you're been charged with. Oh my gosh, that's so funny. Yeah, you don't ever want to have a judge say, let me explain to you what you've actually been charged with. When it's a year later, right? Like he should have a pretty good idea of what he's been charged with. But she's like, nope, you don't. So let me clarify it for you. Oh my gosh. The difference matters. Whether defendant sought to undermine public confidence in the election to legitimize or otherwise further his criminal conspiracies does not depend on whether other nations also try to achieve similar results for their own purposes. All right, that's a pretty strong statement that I think will need to be used by the government. So this should be one of the government's main themes in their case. All right, is going to be the sentence that undermining public confidence in the election does not depend on whether or not there were foreign actors involved. All right, so that's going to be a big piece for them. Lawyer humor. I know. Oh my gosh. All right, so let's see. Accordingly, additional information about foreign actors' efforts is to mislead or inflame the public would not rebut defendant's allegedly criminal conduct. And then she's saying here, explaining that the requested material would not help a third-party guilt defense because the lies told by others in no way exonerate the defendant for the specific lies he told to his followers or the criminal steps that he took to illegally regain power. Harsh. That's harsh. I love it. All right, here we go. Defendant's second theory suffers from the now familiar lack of connection. Oh my gosh. Yikes. Now familiar lack of connection to his state of mind during the time of his alleged criminal activity. The basic problem is that defendant could not have acted in good faith in response to certain reports if he was not briefed contemporaneously regarding these issues. Put simply, his motives could not be based on information he did not know. Yet, his request expressly seeks information of which he was not aware, and it fails to proffer what information he did know, and could therefore seek to support with additional documentation through discovery. Defendant has not adequately demonstrated materiality on this ground. This request also runs aground on a more categorical problem. Foreign influence in an election is not the same as foreign interference. As those terms are used by the government and the sources it cites, election interference refers to the efforts targeted at a technical aspect of the election, including voter registration, casting and counting ballots, or reporting results, whereas election interference refers to a broader effort aimed at affecting elections, including candidates, political parties, voters, or their preferences, or political processes. Generally, 2020, and she's citing this here, the 2020 election ICA. And I'm going to skip down here. Election influence typically involves efforts to spread disinformation, often to falsely denigrate or support a candidate, sow confusion, exacerbate political tensions, undermine confidence in the electoral process, or otherwise influence the hearts and minds of American citizens. The superseding indictment alleges that defendants' knowing deceit concerned elections interference, not election influence. It states that he knowingly spread lies that there had been outcome determinative fraud in the election and that he had actually won. Those alleged lies included dozens of specific claims that there had been substantial fraud in certain states, such as the large numbers of unalive, non-resident, non-citizen, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for the defendant to votes for Biden. But that kind of outcome determinative fraud is fundamentally different from foreign disinformation or persuasion campaigns. So she's already setting out this distinction, everyone. She's saying, well, if you're talking about here versus there, we're talking about two different roads. So you can't mash them together, which again is what they're going to try to say during trial. And what she's saying is that your foreign interference is not the same as our state interference. There's a distinction there. So no one disputes that certain foreign countries to varying extents attempted to influence Americans and spread disinformation. So insofar as defendant seeks to show that he made his claims of fraud in good faith, he could not do so by showing that he based those claims on information that there was foreign influence in the 2020 election. So this is huge. She's handing this on over the government. She's like, here you go, government. This is for you. And the footnote is stating here, defendant disputes the artificial distinction between influence and interference, but rejecting those conceptual categories does not narrow the gap between the allegations of his specific outcome determinative fraud claims on the one hand and his demand for information about foreign disinformation or persuasion efforts on the other. In any event, as discussed in the next section, the court construes defendant's motion as seeking both information regarding foreign influence as well as foreign interference. That leaves just one way in which the records about foreign influence might even be arguable material. If, in making his claims of fraud, defendant contends that he relied on advice or conclusions that turned out to be sourced from foreign information, knowing more about those foreign sources could help him to prepare his defense, that he acted in good faith, even if certain reports were ultimately determined to be inaccurate. Ooh, oh no, everybody. Ooh, the next layer. Did you all catch that? The next layer. So this is going to be part 2. He's saying not only did he have a good faith reliance on information in order to say that there was fraud, but he relied on foreign information that was targeted to make people not want to do what they needed to do. Did you catch that? So he's blaming another person. That's his next spot. So first, he's saying there's not enough security, but now he's saying it was foreign nations trying to undermine our election, gave information to him that he, in a good faith, relied on. So he's saying, like, I was duped. I was duped by this information. I thought it was true because it was so amazing how these foreign adversaries created this information and they gave it to me and I believed it. And, you should feel sorry for me because I'm a victim too. Yeah, that's a whole bunch. This is huge right here. This is a very interesting theory of the case here. As the court has repeatedly noted, however, defendant has not proffered that he based his allegations or his alleged claims on fraud of any particular report or advisor whose sources he now seeks to uncover. So she's saying, but you never said you got your information from a bad source. You didn't say that at all. Nowhere have you said that. Vague allusions to certain reports are not enough, particularly where a request is so broad and implicates sensitive intelligence about foreign activities. Defendant asked the court to be permitted to search for a needle in the haystack of the country's most classified secrets without the slightest indication of what the needle might be. He has not met his burden to demonstrate the materiality of all information relating to foreign influence efforts. So, no, you may not have that information. Yeah, I believed in Putin in good faith. All right, everyone, and I'm looking here at the clock. I will need to stop here, unfortunately. We didn't quite make it through all of the discovery requests, but I will pick this up again as soon as I can. But so how are we feeling about this so far? We made it halfway through her order, her 50-page order. I think we've done pretty good. He's too stupid either way. So, right. So He's like, first of all, I had a right because of my job as commander in chief to make sure that there was no fraud, because I thought there was fraud because the foreign entities were giving me bad information. So he received bad information. Very well. Oh, thank you so much, Lee. That's so sweet. An attempt to get out. Oh, absolutely. Absolutely. So, and what Judge Chutkan is saying here is that even if that's your theory of the case, you can't just go fishing around for evidence to support your theory of the case. Like, you can't look for information. You should have that information. That's how you're forming your defense. But, you can't just go and investigate it at this point. Yes, I have been able to start posting back on YouTube again, or the Tube of You. So this will be the next one that I put up. I'm almost caught up, but I have a little bit. Or line implicates someone. Well, exactly right. So the most classic defenses, right? And this is just my symbol for defenses, so that I don't have to write the word defenses out. Oh, thank you so much. Oh, that's so sweet. You have alibi, right? I wasn't there. Or you have somebody else did it, somebody else. Or like you would just say, well, I was just holding it for a friend, right? I was just holding it for a friend. So my friend is somebody else. So he's saying, well, I just got information from wrong people and relied on it. Silly me, but it's somebody else that gave me the bad information. So that's the defense he's going with here. Or the third one is, again, somebody else, where he's saying, the responsibility for safety was on the National Guard, on those people. And I told them that they needed to have people, but they didn't have enough people there. So that's on them. That's not on me. It's not my fault. They didn't prepare security well enough. So we've got two situations already. Somebody else gave him bad information that he relied on, and somebody else did not properly secure the Capitol. And that's why the riot occurred. So those are the roads he's going down at this point. What happened to all his facts? Well, that's a good question. And that's one thing Judge Chutkan's saying is like, where's your facts, man? Where's your evidence? Because you're not giving any information. You're just saying this could have something to do with your state of mind, which could be helpful because an act and intent, and that could be helpful, your state of mind. But all of this information you did not have at that time. So how could that have affected your state of mind? Like it came later. Like you didn't read that at the time. It wasn't contemporaneous. If it's not at the same time, you can't say it affected your intent level, which I thought was wonderful. Think this case will ever go to trial? I do. I think it'll get to trial. I don't think this case will ever be pled out. I don't think either side would be willing to do that. I think, yeah, it will get to trial eventually. It's going to be a while. I'm too oblivious to know. Well, right. I'm too oblivious to know, but even if I did know, it's my power as the president to do what I did. So he's really arguing all of these different routes. Where do you think the defense is going to take? I think they're going to take all. They're going to go for broke on this. It's somebody else's fault. It's a foreign country's fault. He is protected as the president. All of that information can't be shared with the jury because it falls under the purview of his immunity situation. I think they're going to take all of them and just run with it. Yeah, the classified documents case is on the move right now. We're waiting for Mr. Trump's response brief, which should be coming pretty soon, actually. And after that, we'll see a reply from Jack's side, and then we'll see a hearing set. It's going to take a little bit of time, but, we're still there. Where can you read this online? So if you go online and you put in this case number here, it should pull up a docket for you. It should pull up a website, and it depends on where you are, which website will come up. But you will pull this up and you're looking for document 6263, all right? And then a PDF form of that, and you should be able to find it. Sometimes different news sources that cover that will have a link, an easy link for you. But there's just lots. Yes, Court Listener is exceptional. They do great work there. So that's a very easy place to go and find it. And then you just pull it up, make sure you've got document 263. That's the key here, the memorandum in order. And then you can pull it up and get it and pull it and print yourself. Oh, absolutely. What was the thing about undercover people? That was new to me. So great question. So what I believe he's trying to do is he's trying to get information stating that the undercover people were there for either a nefarious purpose or were there to add to security. So if they were there in addition to the regular security, then that's going to show that, again, it was a failure of the security. It wasn't his failure. But he wants to know who the people were that were in the crowd that were undercover. And in a way that so that he can identify. And we also have these people, and they also failed to do their job. So again, it's not my fault. It's the undercover people's fault. They screwed it up. I know. Yeah, exactly. Has to be harsh to deter from this happening again. That's a good point. And that's one of the reasons why we have punishment, right? Is deterrence. But if you think about it, is this the kind of crime, and I've been wondering about this myself, is this the kind of crime where deterrence is going to work? Like if somebody tries to do this again, are they going to say, well, I better not do that because I could wind up like Mr. Trump? Is this kind of that category? I just don't know. I don't know. What's happening in New York with the appellate court? Nothing. Nothing is happening. Oh, nothing is happening. Cybersecurity. Exactly, Lee. You got it. So, right. Let's take a minute and talk about New York real quick, everyone. There has been some crazy business going on in New York, according to some terrible reports. So let me just tell you right now, all right, we have a civil case, right? That huge case involving like $500 million. And then we have our criminal case as well. All right. Now they're both being appealed along with the E. Jean Carroll cases. So it's all being appealed. So they're saying, what they're saying is like, oh, they had a hearing and the judge threw it out. He got so mad, he just threw it out. Well, no, that didn't happen. Some people somehow are getting their hands on reporting or quotes or transcripts from the hearing. And the judges were very aggressive with the attorneys. And they're saying, well, that means then that he's lost the case. They're going to throw it out. And my thought is, no, that's just what judges do when you are arguing in front of them. So the big key here is the Court of Appeals had a hearing and shot a lot of questions at counsel. And maybe they were aggressive about it, whatever. But that's just what you do in an appellate hearing. That's just how it goes. So those are just the rules of the road and you get used to it. But if you're not used to it and you're just like, wow, that sounds really crazy what he just said, that just means that you haven't argued in court very much because it's relatively normal for judges to kind of go after attorneys. That certainly doesn't mean anybody's case is getting tossed out. So if anyone comes at you with that, exactly, Robbie. If anybody comes at you like it was dismissed, no, it wasn't. It most certainly was not. So there's been no decision yet. They're just fighting it out like we do in court. So glad you're feeling better. Oh, I am. Aren't they always aggressive to try to get to the heart of it? They are, Trish. And, a lot of people don't understand. Our judges have pretty much made up their mind before oral arguments. They're reading the case, they're reading through the briefs, they've already got where their position is. So they may come in with a few questions to see if a counsel can kind of clean it up a little bit or firm up their own spot that they're looking at. But it's more of a, more pomp and circumstance really than anything else, because an oral argument on appeal, it's not going to make or break any kind of situation. You're not going to have that moment of like, oh, right, you're so right. Yes, we'll do that. No. Judges are already coming in. They already know what's going on. They know what's what. And so now they're going to toss a few things at the attorneys, see how they answer it and kind of clarify a little bit. Did you? Yes. Appeals lose that 90% rate. Well, right. And in New York too, they're pretty solid there. I would say in the New York civil case, be prepared for that amount to be significantly reduced. I do not believe for 1 minute that the amount, that $500 million, will stay. I do not believe for 1 minute. I think we'll have a much, much lower number. And based off of what they were asking questions of during the hearing, I really believe that. They're going to try to cut that number down. I think they also are trying to say, when they were arguing that particular code section shouldn't be able to be used whenever the AG wants to. It needs to be very specific. It needs to be a scalpel, not a baseball bat. So I think that also came across in that hearing as well. So I think the money will change. And I think that other than that, I don't see what other grounds on that particular code section in New York would be wrong. They could say your code section is unconstitutional, but I mean, they've had that code section in front of the Court of Appeals for decades, and it's like, well, why didn't you overturn it decades ago? So for me, I think we're just going to be working on how much money. Oh, you're welcome. They should double it, perhaps. But anytime you get a huge number like that, it's you're not going to be able to. I mean, $500 million. Come on, I don't think they're going to bump that down for sure. But that's okay. It's not just about the money. It's about Mr. Trump not being able to do business in New York, right? There are a lot of things. It means he has to move everything out of New York. All of his businesses have to move. His kids got fined too. He's got some problems. So his strongest people in his businesses got hit in the civil case along with him. So the money, of course, kind of hits him where that's a currency he can understand, but there's a lot more pieces to it. And again, the goal is to keep it so that people don't do this kind of fraud. And probably the biggest deterrent is him losing his businesses over it. Their previous rulings. Yes. Not cost. Oh, yeah, it's expensive. Can they have jail time? No, great question, but no. Not in civil court. Not in civil courts. We can't deprive anyone of their freedom. The burden of proof isn't high enough. That's only in criminal courts. We'd have a different burden of proof, which means it's harder for that to happen because your freedom is important. Money is important, but not as important as your freedom. Do you think can never change qualification for the president in the Constitution? Yes, I do. I think this whole process, everyone, has really brought home this idea that, the 27 amendments that we have in the Constitution are not enough. It's not enough. It's like we're really hesitant to add amendments, and I can understand because nobody can agree on anything. The last amendment was added in the 90s. So, I mean, it's been a while. It's time, and I think people are really recognizing it. Now, what exactly that amendment says, who knows? Because Congress is such a mess, they can't agree on anything. I wouldn't think an amendment's going to be coming through so long as the Trump world exists. Once the Trump world is running, once they're done, I think that idea of adding some amendments to clarify some of this stuff will absolutely hit the floor for sure. Right. Well, yeah, I think we've got to nail it down. We've got to do a better job. We've got to tighten up the Constitution in a lot of ways. And it's interesting to see exactly which amendments will be pulled first. But none of that will happen until, the Trump world disappears. That has to go. That has to subside. We're not going to see any movement on that because half of the Republican Party is, kind of in this weird situation where they are unable to remove themselves from their abuser. Do you think this is a delay once times to retribution? Perhaps. Need to get the ERA in the books. Yeah, Robbie, that's going to be the very last piece. That's going to take a long time. They've been trying to get that on the books for a long time. Where's the Georgia case? So Georgia right now, we have Fani Willis has filed a counterclaim for getting 6 of the charges back in the original indictment. We also have Fani Willis has filed her request or her objection to Mark Meadows' writ of certiorari to have his case moved to federal court. So she's just filed that a few days ago, and then her second cross appeals just filed yesterday. So we're still hanging out there. We're still cooking. We're still cooking in Georgia at this point. We're going to have movie night. Oh, very soon, Kristen. Super soon. I know, I missed it. Tea break. Yep, I need to. Oh my gosh. When's the sentencing? So the sentencing is the last week in November for the criminal case. Let me grab my calendar here. Let's see, where did I put it? Boy, my desk is such a mess at this point. Hold on, let me see here. Okay, let's move this out of the way. We've got the Supreme Court, by the way, is starting to hear cases again for anyone who's interested. We have right here in November, Trump's sentencing is set for the 26th. Do you see him getting time for anything? It's possible. I think it's absolutely possible that he could get time in New York. It's possible. I think it's definitely on the table as one of the options for Judge Merchan, and how he works and how he, tries to do the same thing for each people. He tries to be a very consistent judge, and I can appreciate that. And so I think there's definitely a chance. If he's found guilty in Georgia, whenever that case goes, that's a mandatory 5 years, so 2.5. But, given his age and his lack of a criminal record, there's just so many things that go into it. When making that decision, it's going to be a really difficult decision to make. So again, the whole thing is like, what's the purpose? What's the point of accountability? What does that look like? What does that need to look like for Mr. Trump? And that's what the judges are looking at. Where is his accountability? And would it hit home if he was put into prison? Or would it hit home if he was, confined to his home for several years? Like, what is it that's going to make it so that he recognizes he was wrong and needs some accountability? So that's kind of tough. That's going to be a tough road to go down. Yeah, Shannon, I agree. Yeah, he's not making a lot of good choices here, in my humble opinion, but it is what it is. I think Jack's looking into Logan Act. I do not. Now, I've taken a peek at the Logan Act, and I think that would be a very difficult route to go down because the intent element. As I was talking about before, how important intent is. And I think the specific intent that's needed, rather than just an over general intent, but the specific intent needed for the Logan Act, I don't think would be something really worth pursuing. And in my humble opinion, there's just a lot of other routes, a lot of other roads to go down with Mr. Trump. I'm not sure that that's one that would be fruitful for them. To come off from social media. Well, yeah, that could definitely be a part of it, or limited, or have to ask permission before using it. Can they sentence a president? Oh, sure, absolutely. They can sentence anybody. I don't know if any punishment will work. That's a good question. Are these lives on YouTube? Absolutely. So this should be up within 24 hours. This one, I will download it tonight and then upload it tomorrow. I am trying to kind of stay on top of these better. House arrest his perimeter better not include the golf course. Well, whatever. It is what it is. If we have a finding of guilty in these cases, to me, for me, that's plenty. I'm fine with that. I don't care what the sentence is. If we have a jury coming back finding him guilty, to me, that is accountability. The punishment is just extra. But I know a lot of people feel way differently about that. So I understand. I understand that could happen. Conversation. Oh, absolutely, Gabe. I'm happy to do that. I'm happy to help when I can here. This is kind of a weird legal world that we're in right now. We're kind of, walking through it all together. Main reason for wanting prison is to show the country will make right. And that's what's so interesting too here in this country is how prison really is, the standard people use in order to say someone was held accountable. And I'm not saying that's right or wrong. I'm just saying that's just really part of our culture here. And so if you don't get prison, you're not at the level that most people are interested in having. Meanwhile, our poor prisons are so packed right now. And I said poor prisons, and I mean it because we're still human beings, and when you get packed into a prison, that's not good stuff. Yep. Goes to jail, what happens to the Secret Service? Great question. A lot of people have asked that, and I do not know. My understanding from how I've read it is that as long as someone's guarding him, the Secret Service does not need to be there. So it's like they hand the package off to the people in the prison. That would be my understanding, but I don't know exactly. If he lost his base, right. And I'm not sure that anything will take him down that road. I don't think the base would back away from him at any point. I cannot find a single thing that he could do or say that his base would say, well, that's it, we're done. I just do not think so. Vance ends up present. Yeah, that's a scary thought. Not always need to be present. Well, I agree. I think there's a lot of ways to hold someone accountable, a lot of ways, and a lot of really creative ways. So, just going to depend on how things go with Judge Merchan. I think Judge Merchan is the best judge, too, in this situation. I think he will do a great job at being fair. They won't turn. Yeah, I don't think they'll turn. And, it's such a fundamental piece. It's not even what he says. It's not about what he says. It's about, this entity that is far superior to anything else. And once you find something like that to do, almost like a worship level situation, it doesn't matter what they say or do. Everything can be forgiven. Everything can be okay as long as they're still with you, as long as you still can rely on them. It really is almost like a cycle of abuse. And I don't use that term lightly, because when it comes to ideologies and mental work, it functions very similarly. It doesn't matter what the person is doing, so long as you are with that person, because without that person, you are nothing. And that's the fear. The fear is, if I step back, then I'll return to being nothing again. It's very sad. Investment fallacy. Yeah. I mean, if you start admitting stuff, then that's going to be really a rough road for you. And I get it. I understand. Yeah, I don't know, but I don't know. That might be cruel and unusual to take internet away. I think that would be pretty rough. It's going to live forever. I don't know. How serious is it to be held in contempt of court? Pretty serious. For Mr. Trump, I think he was held in contempt a couple times. So in lots of cases, in 2 cases, it's pretty serious. And judges only use contempt as a last resort because it's paperwork and it's a hassle. It's a hassle to hold somebody in contempt. But on the other hand, you got to have rules and you got to enforce those rules. So if you don't hold them in contempt, then you've lost the power, and you got to maintain your power. I'd like to see community service. Well, yeah. Just take away. 10-1. That's right. Sentence of silence. Well, I think that might be cruel and unusual too. I'm not sure. No McDonald's. It's okay to be wrong. We need to be nice to them and forgive. It's such a hard road to walk down, everybody, because, it's friends, it's family, it's colleagues, and you don't, there's a point where you're like, well, wait a minute, how did this happen? But in several countries in the world, and this is what I kind of relate it to, some of the advice they give you is when you're out in the streets and someone comes up to you and offers you a better life and offers you a better existence if you just follow them. And I can't even remember the word that they use. Maybe cultists, maybe, but there are people that target people and they're like, come with me and you'll have a better world. And the push for that is so hard mentally that it really takes a lot to pull back from it. Now, whether or not you can forgive, that's, your world, but it also just is something that exists, that there are people that need to have that person to follow. And, they'll find that person in one way or another, and they just happen to hook him. So it's hard. 2.0. That's funny. Yes. Oh my goodness gracious. I agree. Yeah. I mean, it's tough. Very vulnerable people. Well, right. And, it's hard to think like Mike Johnson, the little dude in charge of the House. It's hard to be like, wow, that guy is definitely a follower. But then if you step back and you look at his support and how he has supported things, there's something missing. There's something missing in that. And so you can see how he would be kind of easy pickings for someone with a level of power that Mr. Trump has. Mm-hmm. Yeah, Mike Johnson. Yeah, he's that little guy, right? I think you might. Maybe he's going to use his health to get out of trouble. Possible. It's possible. Thank you for the review. Looking forward to the next session. Absolutely. So again, we made it halfway through, and I would like to make it through the other half, and I will do another live at that point. But it's a game of chess, true. So grateful for you and your ability to explain. Oh, well, I'm happy to do so. I'm happy to. And hopefully this kind of helps a little bit. I know it's like, oh my gosh, legal paperwork. But if you can get into it and actually understand what it means, it's a lot less stressful. There's less anxiety if you actually get into what it's talking about, rather than kind of how the media is spinning it. This is just, this is just raw here. We're just going through the paperwork. We're just reading it and talking about it. There's no spin here. It just is what it is. Let's not overdo it. True, Suze. True. It's right. Yikes. I don't know. I don't care for him because I did not agree with his amicus briefs. And so after that, I was like, he's dead to me. If you're going to write something like this, you're dead to me. Oh my gosh. That's how I feel. So, but with that, everybody, oh, you're welcome. I'm so happy to help. With that, though, I best close down for now. I think tomorrow's going to be a pretty big day. I think we are going to see that appendix tomorrow. Fingers crossed. That should be coming out. So it's going to be a pretty big day. Atticus is like, feed me. But I have half of this left that I would like to get through, and I'll probably skip through the next piece. But I will be back very, very soon. Need to write Election Day on the calendar. Oh, I'm not willing to yet. I've got trauma. I'm not ready. That's too final. I'll have to put it in pencil. But have a wonderful night, everyone. Thank you all again for joining me tonight. I just adore coming and hanging out with all of you. So take care. I will let you know when the next live will be very soon. Take care, everyone. Good night.